Be a bit louder.
Sure, just a moment. Yes. Am I audible now?
Yes, sir.
Is it sound or you want me to join from another device? Is it
No,
fine?
no, sir. It's perfect, sir.
Perfect. Okay. Thank you so much for the warm welcome, Manav. I'm overwhelmed by the research that you have done on my profile. Precisely the what do you call the participation of mine at different universities, JLU and IIT and all. So thanks for that. Since this is an awareness session, first of all, I would like to apologize participants on behalf of the organizing team. We have had scheduled this session for Professor Nesta Agarwal. Unfortunately, she has fallen sick and she is not able to take up the session, so I'm replacing her. The session is for introduction of geographical indication. Before we begin with geographical indication, we should have basic knowledge of trademarks because this GI was earlier a part of trademark law. Tell me, Jinsi, I'm not audible.
So,
Okay,
sorry to interrupt you, sir. Sir, you are audible, but you are a bit low. Your voice is a bit low.
got it. Give me a moment. I'll join from the other device.
Sure, sir. While sir is joining from other device, I would request all the participants to please drop their name as well as email for the certificates. And Vidita, are you there? Yeah. You please take down the names of the participants.
Yeah, I'm on it.
Okay, so perfect. Fine. So am I audible now?
Yes, sir. Now you are perfectly audible.
Perfect. I know this. There's some trouble with the laptops. This thing's microphone. Anyways, all right. So yes, I was saying that with this session, we should have basic understanding of trademarks because GI, geographical indication, is something that has been a part of trademark regime. It was a part of the trademark legislation previously, which was later on, somewhere around 1999, it was, separated from the main legislation, and the government have enacted other law. This law came into effect in 2003, the Geographical Indication Registration and Protection Act. What all it talks about is it talks about geographical indications, and it talks about protection to the geographical indication. Now, as the name suggests, like whenever if at all we hear what is geographical indication, we'll be able to understand that that has something that connects, connects that has a connectivity with a geography or a particular, origin or maybe a region. So geographical indication, it's an indication which is used on the goods or services which are having special connection, which are having their roots with a particular geography. So for example, if we see what sort of GIs are protected in India, especially in Gujarat, if we see, we have got the Kesar mango, we have got Patan Patola, we have got Kutch, the embroidery work of Kutch. Now, these products are available in the market freely, but that has a connection with a particular geography. Patan Patola, if we take an example of, it's something which is now even Rajkot has got a Rajkot Patolu, but which has a design or some the artistic work only on one side, whereas the Patan Patola, it's known as a traditional it is traditionally known cloth which can pass from a small ring, and that is that is something which is available, or which is originating from a pattern. Now, do you think that the origin has to do anything with this manufacturing or like maybe weaving of the of this product? No, but the community, the Salve community, who was originally creating or was producing this product, they were basically staying at Patan, and they started their business from Patan, and this particular product became so famous that people now recognize it as Patan Patolu, and the name of the region has become has been attached with this particular product. Similarly, there are some other product which we use on daily basis. One is Darjeeling tea. Now, if those who are tea lovers, for them, a tea from the Darjeeling is the best tea, which has certain quality, which has certain, like, a particular kind or type of a taste which is not found or which is not available in other forms of, or other other teas which are manufactured or are originating from other places. Why so? Because that of course the climate and condition of that place, and with that a particular way of manufacturing has created this product, and has made this product so famous that people recognize tea with that title of the geography. Okay, this is a Darjeeling tea, let's go for it. It would be amazing, it would be great, it would be best. So that is how we connect the product with a particular geography, and that is what is protected under this particular law. What Geographical Indication Act says is that whenever there is any product which has a connection with a geography which is so which has become so famous, and that being famous is directly an attribute of a particular geography, and it has a connection with the geography, that has to be protected for those who are living in that geography, for those who have created this product, so that the product can be sold only by them, so that they can be benefited for all their efforts, and so that the economy of the country, at the end, what the laws, or what our government would want to see is that the economy of the country is enriched. It's getting getting to the other level, and we are getting some benefits. Ultimately, the country is getting some benefit. The exporting of such goods would be increased. People would want to buy it. Why? Because that has some specific connection, and that has some specific qualities which people would want to look for. So with that basic understanding of geographical indication, we have got a video to show. I guess I would call upon Tushar. I have shared a link of the video to him. So if he can, Tushar, if you are there, please, if you can play the video, and then I'll begin with the other infringement part and the rest part of this particular session. Do we have Tushar present here?
So I guess he's not there. So the host who is hosting, can he or she be?
Rahul. I guess
Yeah.
it could be Rahul Bhavsar. Rahul, would it be possible for you? Lakshita. Yes, Lakshita. Lakshita is raising hand.
Or Rahul bhai, you can just make Lakshita be the co-host so that she can assist us with the video.
Oh, great. Okay. Otherwise, I can also do it from the other system. It's okay. Again, the problem is the connectivity there. Rahul, can you make Lakshita host?
Yes, sir,
Yes.
done.
Lakshita. Okay. Thank you. I guess it's taking a little more time. So let's do one thing. I'll start with the session, and Lakshita, you can show it maybe a little later once it's possible. Just let me know. Okay. So let's not further delay this session, because we would have to complete it on time. All right, so let's just proceed with what else is there in this particular law, geographical indication. So as I said, it is a law which talks about, or which has a connection with the geographical geography, and it aims at protecting the goods which are having specific connection with some geographies, and by that protecting the authorized users, protecting the communities who have worked so hard in bringing this particular product out to the market, to the public, and by that to ensure that the intellectual minds which have worked behind these products. Of course, the geography is there because of which it could be either manufactured, it could be either originated, it could be either produced with at the geography in a particular geography. But whatever it is, that connection is established, and that intellectuality which is behind creation of such products is protected by this particular law. Now, the definition of geographical indication, the section 3E of the Geographical Indication Act of 1999, what it says that GI is something which has a relation, or which identifies goods which are one manufactured, which are second originated, or which are one which has some specific attributes with the geography, and because of which they are protected. Simple examples, or the basics examples of this is Darjeeling tea, basmati rice, we have Patan Patola, Kashmiri Pashmina, then of course Mysore silk is also there. Now these are the GIs which are being protected. How to get a registration of GI? You just have to either the community of the persons who have developed the product to go and approach the GI registry. The registrar will this process is also very simple. Will assess your application, examine the application. It would be published in the journal for inviting the objections, if there are any objections or not. If in case there are no objections, then it would be simply granted. The registration would be granted. After the publication of this GIs, your application, whatever, suppose if I come up with an application of a GI for maybe what is famous? Okay, Surat no Locho. That is very famous in Gujarat, right? Which has yet not received GI. Now, suppose if I am from Surat and I come up with an application that I would want to have a GI on Surat Locho. I am one of the producer of this food product and would want to have a GI of this. So I have to simply go for the registration, application to application of registration to the registry of GI. The registrar will assess my application, will see whether my product has the capability of being registered as a GI or not, whether that is the capability is determined on the basis of the definition, section 3E of the GI Act, which sees whether there is a connection between the geographical indication and the product or not, whether the product is actually originated here. Because if we see Baroda, the Baroda Chawanu is very famous. Surat no Locho is very famous. Now, if these products are having, whether the Baroda Chawanu is available in Ahmedabad with the same taste, with the same quality, no. So that means that product has got some connection with the geography. So the moment that connection is established, the moment that is being proved, And how it is proved? It is proved by showcasing the evidence that how this product is being produced in this particular region, or is being originated in this region, and is being is being known as with the geographical name of the particular region. And after assessing that, registrar would simply publish it in a journal, and that journal would do what? That journal would publish it like would keep that what do you call application published, that okay, somebody has applied for Suratno Locho, so whatever objections are there to that should turn up. In case there are no objections, and even in case if there are no objections, in total 3 + 1 month, that means 4 months would be consumed in this process of assessing or examining the geographical the application which is made for the registration of GI, and the GI tag would be granted to the applicants. Now it may happen that you are also belonging to the same region, and you also are one of the manufacturer, and your name is not mentioned there or you are not you are not one of the applicant of that particular application that has been made to the GI registry. So what you have to do is you have to simply make an application for addition of your name along with your proofs that you are also one of the manufacturer residing in the same region, having this business from a particular duration, and you would also want to be benefited with this protection. So your name also would be registered there. So that's a simple registration process of the geographical indication. Of course, once the rights are conferred to you, that you have got the geographical indication on Suratno Locho, for example, no one else can produce or manufacture this particular product with the name Suratno Locho. They can otherwise with the same quality, with the same taste, they can follow my recipe, they can follow everything, and they can sell off the product, but they cannot use the term called Suratno Locho, the geography's name because of which it has become famous. That cannot be used by anyone else than the registered authorized users. So that is the primary rights, the primary exclusive again right, which is being granted to the authorized persons who have got the registration in their name, in their favor. Okay. Other than this, what is the duration of protection of GI? So same like trademarks, GI is something which is initially the protection of the same is granted for 10 years, but again it can be renewed with the maximum year limit as 10 years. So you can and then again it can be renewed for infinite time. You may keep on renewing it after each 10 years, but at a time you can renew it for only 10 years. You have to make a particular application, you have to pay the requisite fees to the registry, and you can renew it renew your geographical indication, which the GI that you have received from your product. Other than this, what the act offers or what the act says is that the geographical indication cannot be assigned or cannot be transmitted like how we assign trademark. Trademark is something which is free, which is free for the person to assign or license, and by that what you can do is you can take monetary benefits from that. You can take royalties from it. Say for example, Domino's is the company which is not originated in India, but we find Domino's all over India, every region, every here, every corner of the country. Now how it is possible? It is possible with the franchisee agreements that are being entered into between the parent company and the persons who are interested to establish such business in the country. So there, within those franchising agreement, this trademark, the trademark of Domino's is, along with, of course, there are so many other IPs, and technologies which are involved, which are transferred from one particular company to the company, from the franchisor to the franchisee. That means the one who is taking that franchisee. Unlike the trademark regime, in case of geographical indications, since it has specific connection with the geography, since it is something which talks about the public good, which talks about the community right and not an individual right, it is prohibited to be assigned further, it is prohibited to be licensed further or transmitted further. So suppose if I have got a GI on Ratlami Save, I cannot sell it to anyone to further manufacture or sell it with my name. It could be done, it could be sold with by my own company, it could be done by me only, it cannot be done by anyone else. I cannot assign or license or transmit this particular right that I have with me. Now suppose if someone someone misuses my GI. So I have got the registration, I have got all the right over the geographical indication. What further can be done? So suppose Manav comes up tomorrow with with maybe Suratno Locho, then a product maybe which is fixed, which is produced in a tin, and over that he is writing that this is Suratno Locho coming from Manav and Company, whereas earlier it was registered in my name. What I can do is I can file an action of infringement here. Why? Because my product, that my geographical indication is registered one, and it is registered in my name. So I can take an action of infringement against Manav, that what he has done an infringement of my registered GI, and he should do what? There would be specific reliefs from the courts that can be granted. So court may ask him to may pass a freezing order. So he might be freezed to his whatever his premises are there where he is manufacturing the goods, it would be freezed, and court may ask the inspectors to go and conduct inspection. The court may even ask for the discovery of documents. There could be some damages and accounts of profits that Manav might have to pay to the original authorized users. That means if at all he has done any profits over his business, he has to pay it back to me. So the court might grant such reliefs to me, and there could be a civil as well as criminal remedies in case of geographical indications infringement as per the GI Act. Now, first action in case of infringement that lies at the district level, district court, and then it may be passed to the High Court or the other courts. Other courts could be approached. So this is something about the geographical indication. This is something about what the what the GI Act, a very small legislation, talks about. Now, knowing this, we should of course have an understanding of some case laws. So one very famous case is the case of Tirupati Laddu. Now, Tirupati Laddu is the laddu which we all know is available in a particular temple. The temple is known as Tirumala Tirupati Devasthanama temple. Now, this temple produces Tirupati Laddu, and it is so famous, it is so distinct with its taste and quality that people really know that this is coming from this Tirupati Laddu. If we take an example of Gujarat, we have got Mahudini Sukdi. Mahudi temple has got amazing Sukdi which is sold only within that premises of the temple, and it has a very different and unique taste. Now, what happened in this Tirupati Laddu is this temple, the temple owners and the trust, the trustees of this temple, they went to the registry of GI and they filed an application for the registration of Tirupati Laddu. And the main contention or the intention of them was that this laddu is being otherwise sold by the local, local halwai people. And then what they are doing is they are selling it with the name called Tirupati, and that is actually confusing consumers, that is confusing people who are visiting, who are visitors or who are tourists of the region. And that has to be to prevent them. If the GI is granted on this particular laddu, it would be better for us, and it would be of course will be able to refrain such people from gaining undue advantage over or maybe by establishing wrong business in this particular region, and it was granted also. It was, like, of course, very surprising for people, on the basis that Tirupati laddu is something which is being which has a connection with the religion, and if we go through the act, the Geographical Indication Act, it and precisely the provisions with regard to the registration, it says that something which is hurting the religious susceptibilities of the people, or which has connection with the religion should not be granted registration. And there are multiple other things also, that it should be distinctive in nature, distinctive in character, it should have it should not be morally wrong, it should not be something which is deceiving the people as to its what do you call its region, its from where it is being originated. So many things are there which are mentioned within section 9 of the geographical indication, with the tag called prohibition of registration of geographical indication. So people actually oppose that this granting of GI to Tirupati laddu is actually against what is there provided under section 9, and it is something which is not, again, morally right also, that you are granting laddu GI to a laddu which is having connection with a particular religion, and by that you are saying that you would not want to sell it to those who are not following this particular religion, those who are not visiting that particular temple. So you are basically asking people to actually visit the temple and then purchase the laddu. So that is something which is not constitutionally also right, and is going against the constitutional rights. And with these intentions, there was a petition which was filed somewhere in 2009 to the Supreme Court, which was not successful, and the registration to the Tirupati okay, Manav, thanks. Tirupati laddu was considered valid, and they have had the registrar had suo moto taken an action of revisiting, reviewing the application, and after that also the laddu was considered as Tirupati laddu was considered as a valid product to which the GI can be conferred or given. The second case, which is again very famous, and which had interesting facts because of the connections of the people or regional people, was the case of Rasgulla. Now Rasgulla is a product which earlier got GI in West Bengal. Now West Bengal got registration of the Rasgulla as a GI, and post to that, Odisha also filed an application for the registration of the Rasgulla in their favor. Now, of course, to this the community who were residing in Odisha and West Bengal, they started making a lot of videos, and a lot of whatever campaigns were also going on, whereby they were claiming that that Rasgulla was originated somewhere in West Bengal first. Odia people said that it was originated in Odisha first. So this campaigns were going on, and while this was going on, the GI registry had granted GI tag to even Rasgulla of Odisha. The basis on which the GI was granted was on the quality of the product of West Bengal and product of Odisha. The Rasgulla from both the regions have different characteristics, have different mechanism of production. That means have got different recipes and have got different tastes, and by virtue of which they said that both the products are are worthy to receive the protection under the GI Act, and hence the Odia Rasgulla was also granted GI status in what do you call in the in the registry by the registrar of the GI. So this is something with regard to geographical indication. The purpose of this session was simply to aware you. So now I have not touched on the international aspects, which are, the articles which are there under TRIPS agreement from Article 22 to Article 24, which talks about geographical indication. We also have got the Lisbon Agreement, which talks about geographical indication, and again that is also something which is altogether different, because it talks about appellation of origin and it talks about the GI in altogether a different form. Of course, the same form that we have enacted or the way we are protecting it, but it has a wider application to consider. So we are not touching on those aspects, considering that this is an awareness session. So we should have a basic understanding of geographical indication or the laws related to it. If in case you have any doubt or anything, you can let me know, post to the video which Manav has got to show. So that's again, awareness video, hardly of 5 minutes. Manav, if you can do it, it would be great.
Thank you. So, Vidita, please start the video.
Yeah, just give me a second.
Okay.
Is the screen visible?
Yes, Vidita.
It is visible, yes.
In India, traditional crafts and windows have a long and glorious history because of their inherent value, perfection of designs, motifs, eminence, and distinctive style. Skilled artisans and weavers in various regions of India have been demonstrating unique skill sets passed on as legacy over the generations. Whether it is Banarsi brocade, Bhagalpur silk, Tanjavur painting, Madhubani painting, India indeed is a fascinating reservoir of many such exquisite products. This rich cultural heritage of India has attracted consumers not only from all over the country, but from all over the globe. This provides an immense potential for our boosting exports, as well as the economic prosperity of our artisans and weavers. However, the unique quality and aesthetics of these products that rightfully belong to their specific regions often attract dishonest business practices, and most of these products experience infringement. So the question that often comes to mind is, what has our government done to provide legal protection to these products from infringement and duplication?
Hello. Have you heard of the term GI? Well, it stands for Geographical Indication. In fact, in compliance with International Legal Framework of Trade-Related Intellectual Property Right, TRIP's agreement, the Government of India has enacted Geographical Indications of Goods Act 1999. The good news is, till April 2017, a larger majority of 149 handloom and handicraft products have already been registered under the GI Act, thus adding up to a total of 270 products of all categories registered. Now, the important question is how to obtain registration under the GI Act. Well, any association of persons or producers organization can apply for the registration. Once the registration is granted to a product under GI Act, any individual producer, artisan of that geographical area can oneself as an authorized user of that particular GI product. Let me now tell you the benefits of registration under GI Act.
Registration prevents unauthorized use of registered GI name and provides legal protection to the registered proprietors and all the authorized users of GI products. The GI Act provides punishment for infringement or duplication. Therefore, GI registered stakeholders can capitalize on the premium price associated with these premium products in the national and international markets. It also provides complete quality assurance to the customers about the genuineness of the product.
Today, a lot is being really done by the government to help handloom weavers and handicrafts artisans for obtaining GI registration.
The Ministry of Textiles provides financial assistance for bearing the expenses of registration under GI Act. Its various agencies, such as Textile Committee, NIFT, field offices of DC Handlooms, and DC Handicrafts, have been proactively working for getting prominent products registered under GI Act. The ministry has conducted a large number of awareness workshops and is also assisting registration holders in enforcement of their rights. The Honorable Prime Minister of India launched the India Handloom brand on the first National Handloom Day on 7th of August 2015 to promote exquisite, genuine handloom products. The brand has already covered 41 handloom products registered under GI, which are being proactively promoted by the Ministry of Textiles. The ministry also organizes special exhibitions for GI registered products and undertakes special marketing campaigns. Artisans and weavers with GI products are given preferences in all exhibitions.
So, where should one go to avail these benefits? Well, for any help in terms of registration or marketing under GI framework, handloom weavers can easily contact their nearest weaver service center. Similarly,
Okay.
artisans can contact their nearest hand.
Shall I stop here?
Yes, yes. Thank you so much, Vidita.
You're welcome, sir.
All right. So if there is any question with regard to geographical indications, just let me know.
So, can I ask one question?
Please go ahead.
So my question was, I was listening and I thought कि जब हर एक चीज मतलब ये रहता है ट्रेडमार्क रजिस्ट्रेशन है पेटेंट रजिस्ट्रेशन है सबका then why specifically of geographical indication registration is needed for intellectual property right? I mean बाकी it is if we see that we cannot make a specific product in the name like Bengali Rasgulla को जैसे मिला है so we cannot open with the name of Bengali Rasgulla but we can copy everything.
Yes.
If
Yes.
I'm not wrong.
Okay.
Yeah.
So correct. You are right. So geographical indication or GI tag is specifically granted to ensure or to promote the GI based geographical goods or the products which are coming from a specific geography which have become famous because of that geography, so that that particular place or the region's economy is getting improved, or people are purchasing it, people are giving favor, are selecting it, choosing it, right? If in case now, if we talk about trademark is something that deals with a company, specific company, individual, whereas GI is granted to the community of people. It's granted to larger people, right? Why it is granted to the or why should we have that, whereas we can anyways copy it, is that particular name of the geography or that connection is so famous that because of which people has the as their choices, or because they make the choices. For example, if you are basically from Gujarat, you would appreciate Sankhedano furniture. People would want to buy Sankhedano furniture, and then they would want to go ahead with that furniture instead of in place of any other local furniture, even if it's coming from amazing brand. But they believe that the quality of Sankhedano furniture would be amazing, would be of a certain category, right? Now, it is the GI Act is not prohibiting anyone from pursuing that business. So you are right. I can have similar business, or I can have a business with the same quality and characteristic, but people would not buy anything from me until I do not give that tag, that geography's name, right? So in absence of the connection, I'll not actually get what those people will get, and that is what the GI Act is intending to do. It's intending to benefit those goods or the products or the the hands behind those products that has connection with the geography.
Okay. So allow me to
Right.
read a
Yes.
question by Chintan.
Yes.
Jain.
Yes. I guess
So
yes.
take
I could see. It's okay. I'll read it. So Chintan is asking, take an example of a food item which is famous and prevalent in a state or particular geographical location. Let's say misal pav of Maharashtra. Yes, if I being a resident of Gujarat, come up with my own variation of the recipe and giving it a local taste, can I register the same for GI tag? Okay. See, Chintan, you can register it as a GI provided that you can establish connection of your geography with your product, and that connection is not something which you can establish within a year or two, right? You need to have sufficient years of practice or the profession of that business. You must have you must be doing this business, and that particular product must have reached to the minds or the hearts of the people, that people have now started recognizing, okay, this is Ahmedabadi misal pav or maybe masala pav, if you have changed the name also, right? So that connection and that quality of being famous with the the geography which has the specific attribute to the product, that is something which would entitle you to get the registration, right? So that is something, the how the GI is or GI tags are granted.
participants sending more questions, please drop down in your chat box or raise the hand to simply just unmute yourself.
Yes, if there are any other question, we are not there. We do not have any prefixed questions today. So wow, Mrutyunjay is there.
Mrityunjay,
Please, Mrutyunjay, you can unmute yourself.
Good afternoon, sir.
Hi, good afternoon.
So my question was related to the remedies you stated in case of infringement of someone's GI. So I remember the remedies you said were first that discontinuance of any such production of a tag whose GI has been preserved, and second remedy was to give a part of the profit one is earning, the defaulter is earning, to the original holder of that GI. So in that case, would the second remedy, which was giving a part of profit, would be kind of helpful? So because it defies the whole point of having GI, would giving some part of profit actually preserve the uniqueness of that product with that place?
Correct. Okay. So the remedies which are available are one is damages. The damages or accounts of profit would be granted to the applicants. That okay, this has happened. It would of course be stopped. They would be refrained from continue with that business. But if someone has have had a business for maybe a specific reasonable period, whereby he or she has got some profits over that particular with that product, that profits also should be paid back to the what do you call to the owners of the GI. And that's not just the just remedy which is there. In case of infringement, the remedy which is there is imprisonment of 6 months to 3 years, and like the amount of compensation that has to be paid is from 50,000 to 3 lakhs rupees. So that is something which is there in case when the infringement has taken place. But with that, courts also grant this damages and accounts of profit if in case the applicants are asking that okay, you have granted the amount of 3 lakhs as the compensation, but that's not sufficient. They have the infringers have had a business of a longer term, or like of a higher amount, huge amount. Then in that case, the court may even ask for the accounts of profit. Now, whether that is fulfilling, or that is ensuring the uniqueness of the GI or the objectives which were there behind the legislation granting the protection, and that nexus is established or not, that is something which is left on the courts to decide. So they, on the basis of the cases, what sort of facts were there, how it was infringed, what was the which for what term it was infringed. On the basis of that, they consider this damages and all. So and then they grant the damages. I hope I could reach to here. With that, I just recollected that it's not only infringement that is granted in case of GIs, even passing of remedy is also available for the geographical indications. Now, what is passing of? Passing of means in case when there is no registration, in case there is an absence of registration. Just as Surat no Locho is not registered in Surat, right? It is not a registered GI. But suppose if I start business of Surat no Locho here in Gandhinagar, people might come up, or the manufacturers or the business owners from Surat might make an allegation that this is nothing but passing off of our name, which is if in Gandhinagar I start a business with the title called Surat no Locho available in Gandhinagar. So the people from there, they may say that since this person is not belonging to Surat, since this person is not the things are not coming from the Surat, there is this is a passing off of our product, and that passing of remedy, which is otherwise known as a common law remedy, is also available to such to such community people who do not have the registration of the product or the GI, but even then they can take an action against such wrongs or maybe misuse of their titles or their names of their business. So that is also something which is available. I hope I could reach to you here, Mrityunjay.
Yes, sir. So in accordance with the same Surat case, I remember a case. So do you know that Kadaknath Murga from Jhabua has a GI? So it is actually black in color, and they are super strong. So
Correct.
what happened was, some businessmen in Bhopal started to breed the same species of cock in Bhopal, and so in the same similar climatic conditions, giving them similar diets and the similar forestic environment as well. So what the court
Correct.
decided in this case was that they are merely taking the name of Jhabua's Kadaknath Murga and not actually earning profit from that name. Wasn't it a bizarre decision?
Well, see, it depends. Which I'm pretty unaware of this particular facts of this particular case that you are discussing. But then, what I believe is that if the court has intervened into this and has found that this is something which is, if at all they are not earning profits with that particular name, we may have to consider it. See, I would not say that we have to think otherwise from what the court must have decided in the case, being unaware of the facts actually. Otherwise, I would have given some more inputs on this particular case. But then what we can do is I'll go through the case and we can have a discussion on this case, and maybe what sort of other things can be done maybe in any other session. You can reach to me otherwise also, so we shall discuss over it and we'll work on it. But yes, it is possible. See, if the court has found that there was no profit which was gained by the equal profit which was gained by particular owners of those who are producing, not production, these were the chicks. So whatever birds were they were in the business, whatever business they were running, if at all they have had no intention of profiting or of taking and having any profit with that title, it won't be considered as GI's infringement, because the infringement that has specific connection is with the earning capacity of the authorized users, that or the capabilities, whether you are directly encroaching their finances, the finances of authorized user. So if at all that is absent, if that intention is absent, then in that case the court might have found that okay, this is something which is which is not GI infringement. So that could be considered as valid. But again, I shall go through the merits of the case and shall discuss with you.
So
Sure,
there
sir.
is one question which from Shruti Sharan.
Yes.
So the registered proprietor should not necessarily be a group of a people or association, but a single people also, but a single person also. Also, what happens if the registered user dies during course of GI tag validity for 10 years? How does the transfer?
Okay.
How does that transfer and to whom?
Okay, so GI is something which can be granted to a single person, can be granted to a community person. It can be inherited also by the further heirs if they have the same skills and if they can produce it, if they were into the same business of their parents or their ancestors. They have to simply get their names added in the GI registry with, of course, the approval of the original GI holders, that the quality of that particular product, that GI, is maintained even when these people are into the business. So then they can be added there. So how it can be, like, it how, suppose if there is only one person, just as Patan Patola is being produced by a particular family, and now there are very few people in the family. Let's hope it doesn't happen, but for example, if there is no one who's left in that family, of course it would, that quality would not, no one else will be able to produce that quality, and then that GI will, that whatever protection is, that it won't be granted to anyone else. But yes, people can come up with their own different versions of such what do you call products, and may say that we would wish to be entitled to this particular tag, because our product has some quality, some similarities there, so that may be considered by the registry depending on the characteristics. So this actually happens in case of agricultural goods. Just say we have got what do you call some oranges from or maybe let's say kesar mango from Junagadh. So when we talk about these mangoes, people, there could be some people, suppose if I am here in Gandhinagar, I transfer to that particular region and I start cultivating this mangoes, kesar mango. I can get my name added if I have the farms there, and if I am also one of the farmer there, so I can get my name added there. So that is how the mechanism is there to get the names of the persons added, or the GI is being granted to further other persons. Okay, so do we have any other questions? No. All right, so let's have a closure.
Yes, sir.
Thank you so
Participants are
much.
requested to.
Okay, I'm sorry, Manav. So
No,
thank you so
that's
much. Thank you so much, everyone, all the participants who are there, for being there. If you still have any questions, any confusions, you can reach out to me over WhatsApp. Mrityunjay, you can also reach out to me to discuss about the case that you were saying. I shall go through the merits of the case and shall let you know further things also, right? So that's it, and thank you so much, Student Governing Council, for making the last moment changes that we have had today because of the inability of one guest, not guest, one professor speaker. So thank you so much for ensuring that everything runs, and thanks, Manav, for the warm welcome, and for you were amazing host. I love the way you anchored and you managed everything. Thank you so much, Manav.
Thank you so much, sir. So I, on behalf of Student Governing Council, want to express my gratitude to you on clearing all the nuances related to GI, and also want to thank the KU management and all those who have been closely associated with this webinar, and without whom the flawless flow of the webinar would be a distant foe. Thank you all my seniors and colleagues who had volunteered, and last but not the least, thank you all the participants who are present here. Thank you so much. And I would request all the participants to please turn on their camera and Vidita to take the screenshot, and same participants please drop their name along with the email ID for certificate purposes.
Thank you Manav. Please, all those जिनके भी registrations नहीं है वो करवा लो, और the one who was looking after the participants, please अरे participants registration please copy paste करके ले लो इनको, इनके नाम और सब कुछ, right?
Okay.
Yeah. Thank you. So shall we close the session now, Manav?
Sir, just a second.
Shreya
Sir,
Purani.
Deepika is